for the first time, the Supreme Court may have its full complement of 21 justices of, well, that's if the recommendations of all the 11 recommended justices, given by the National Judicial Council is confirmed. A statement by the Apex Court's Director of Information, Soji Oye, says the recommendation of the 11 new justices was made at the 104th meeting of the Council in Abuja, and these candidates, the recommended candidates that is, will be sworn in after the approval of their recommendation by President Bola Tinubu, as well as the subsequent confirmation of their appointment by the Senate. And with this appointment, the Apex Court will have its full complement of 21 justices as envisaged by the Constitution. Those recommended for appointment to the Supreme Court are Justices Jumai Sankey, Chidebere Uwa, Chelma Nwosu Iheme, Haruna Samani, Mora Dumain, Justice Obande Ogbunya, Justice Stephen Ada, Justice Habib Abiru, Justice Jamilu Tukuru, Justices Abubakar Umar, Mohammed Idris. These are all the 11 recommended individuals to the Apex Court. And of course, as has been said, these recommendations are pending confirmation by or approval by the President and confirmation by the Senate. We have joining us now in the studio to talk about this conversation two lawyers and public affairs analysts, Jide Ologun, as well as Olatubosun Oshufowora. Welcome. Good to see you,
Thank
Mr.
you very
Ologun
much.
and Mr. Oshufowora. And what do you make of this this development? It's been, a clarion call, very persistent. How is it the 10 or the 11 justices on the bench, how they could have been, been managing all this while? Can we have a full bench finally? And now we're having, 11 justices. Well, recommendation as we speak now, pending confirmation and approval. How does this picture? Let me begin with you, Boss.
All right. First off, the implication of not having a full bench has it's been telling on lawyers and practice generally, because I can tell you for free, and my letter senior here will confirm the same thing, that getting a date for simple applications at that level, in fact, from the appeal court even to the Supreme Court, in the past 1 year, people have been given 2025, 2026 dates. And, like the normal balance that justice delayed is justice denied. There are things that requires urgency. And also, what was given priority this year were electoral matters. And so that means that lawyers had to wait in the wings for this. But now that you have the full complement of the bench, then I think that helps, practice, that helps. It saves time. And also it puts less stress on the justices as well, because you can imagine like literally half of the people that are supposed to be on the bench having to do practically everything. That's telling, and that will take a toll on them, on their health and every part of them. So it's a welcome development. It's a good one for the practice. It's a good one for the judiciary. And we hope for the best for the new justices of the Supreme Court.
How much of, a breakthrough are we having, before us, Mr. Ologun?
I'm quite amazed and excited because we are now respecting the provisions of the Constitution. If you look at Section 230 of the Nigerian Constitution 1999 as amended, it prescribes that we have the Chief Justice of the Federation and additional 20 justices, considering the enormity of the assignment in the Supreme Court that became the highest court in the land since 1963 when we became a republic. And like my colleague brilliantly mentioned, if you have a matter in the Supreme Court, you may not be in a hurry. You see, sometimes they give you about 11 months adjournment, and you don't even know when the next one will be. But having said that, I think we should look beyond and consider what needs to be put in place to make the judiciary more effective. And I think since 1869 or thereabout, you have just 9 justices sitting in the Supreme Court of the United States of America, and they've been effective. So you have to look at the link between the tiers of court that we have in the country, talking about the Magistrate, High Court, Federal High Court, the Court of Appeal, and the Supreme Court, to see how we can be more effective. Is it in the area of equipment? Is it in the area of, so these things are important. But I applaud the fact that the Chief Justice of the Federation, Honorable Justice Ariwola, is saying that in my own time, and reportedly so for the first time, the Supreme Court is going to have 21 justices. And again, I want to prompt the National Assembly to look at the provisions of that law, because if you look at that section 230, it gives the National Assembly the power to determine the number of justices that will be there. So they should look at what we have on ground and see how the Supreme Court, where you expect to have the final attention to justice, is well equipped, and it's not like an eagle flying, attempting to fly with one wing. So we expect that this will be done, and we have, of course, 3 steps to this. The National Judicial Council, they've done their own, and to present the recommended candidates to the President for approval, then the final endorsement by the Senate. And we expect that when this is done, the impact will be felt in how speed is given to justice, because one of the crucial elements of seeking justice is speed, because sometimes the subject matter would even have been taken out before you finally come to the end of the rope. So it's quite impressive. And permit me finally to say that the National Assembly also, that is mandated by Section 4 of the Nigerian Constitution 1999 as amended, issue, to make laws for the peace, orderliness, and good governance of the nation, look at all this. And I'm asking a crucial question. What happens if we are expected to have 2 pilots flying an aircraft to New York City from Nigeria, and there's only 1 pilot? So that provisions of the Constitution, how do we ensure that at every point in time we have the maximum number of justices in the Supreme Court? I think that is something that must be paid attention to.
You said earlier on that the National Assembly also has no powers to determine the number. Are you, by any way insinuating that perhaps we also need, in calling for reforms, we also need to increase the number of justices of the Supreme Court?
It depends on what their engagements and their evaluation, prompts up. I have just told us in the United States of America, there are just 9 justices, and since 1896 or thereabouts, sitting.
But then our legal systems are different. In Nigeria,
theirs appear to be more effective. Recently too, we had a very disturbing scenario coming from the Supreme Court when the justices themselves were crying foul of corrupt practices and ill equipment to carry out their functions, as much as low as internet services, going for courses, for improvements and everything. So we need to look at this in a holistic manner. We need to develop a system that will reposition the judiciary to the platform of respect. It's a very sensitive arm of government. So this is a step in the right direction, and if achieved, kudos to the present Chief Justice of the Federation, Honorable Justice Kayode Ariwola, and I'm just requesting that when we fulfill that full complement, how do we sustain it so that we don't come back to a situation where we are saying in the future that there are just 8 justices, in the Supreme Court, because when they sit, they're expected to sit in a team of 5. So that means you have 2 teams basically to attend to, and you have all the political cases, the civil, different kinds of matters before the Supreme Court. And for lawyers, it's not palatable. Imagine that you have a matter in the Supreme Court and you have to travel from Lagos, and all you get is an adjournment that you come back, so all those expenses and stuff like that. So look at the judiciary holistically, because I know the National Judicial Council created by Section 153 of the Nigerian Constitution 1990 as amended, has a tripartite assignment to recommend appointments of justices, recommend for their removal, and of course carry out oversight and disciplinary functions to ensure that we have professional excellence. And when all these are carried together, we may begin to gain credibility in that sector of our national life.
All right, Mr. Oshufowora, so what's your take? As Mr. Ologun here said, it is a step in the right direction, but then, that is not all, because we understand that, some of these justices, we've had justices who even voluntarily, retire from the bench. And now, okay, the compulsory retirement age is 70. What are your thoughts, on what next? By the time they get approved, the appointments are approved and confirmed, what next regarding, the speed of, adjudication of cases and, all other concerns?
First of all, if you look at I was almost going to use sporting time, football time, first 11 and second 11. If you look at this team of 11, I think consideration was given to age as well, because one of the things that has been a problem over time is by the time most of those justices get to the apex court, you find out that some of them are very close to the retirement age. So two things now speak for them. They've elevated the age from 65 to 70, and also if you see some of the people on this team now, some of them are still, not that old, like we used to know them to be very old. Now, so there's a lot of time. And I think that allays Mr. Ologun's fears that we wouldn't have to rush back again and start looking for how to make it another 21, because some of them are still going to be around for some 5, some will be there for like 10 years. Now, so that means, but at the same time also, maybe let me use the first 11 that's there right now, or the first team that's there right now at the Supreme Court. You find that some of them are very close. I know the CJN, any moment by next year, thereabout, he's moving. The next in line also has about a few months, almost a year, and same for the third person. Now, so I think one of the things we have to look at and guard against is to not to have the same scenario we had where, like, he said earlier that if you have, normally they sit in team of 5. If you have constitutional matters, they sit in team of 7. Now, so that makes it tedious for them, and it puts a whole lot of workload on them. Mr. Ologun had alluded to the American system, that they have 9 justices at their own apex court. But one of the things we failed to bring forward is that at the state level, they have their own apex courts too, that some matters don't have to go all the way. We just have one Supreme Court, and then whatever happens from the lowest court in every state, you find out that everybody goes to that one Supreme Court we have, unlike the American system. So their structure is different from what we have here.
So the caseload, obviously,
is not as much as we have here. Now, but trying to adopt or adapt to their own system, it's a big constitutional issue that will take almost forever to put in place. But with what we have, I think we can manage what we have and then make sure that we get the best out of it by ensuring that you don't have to wait until the point where there's so much massive vacancy at that level before you start bringing in people. You can also, I think the necessary parties or bodies saddled with this appointment should preempt some of those things and act timeously so that you wouldn't have this kind of situation we had, because having just 10 people then having to appoint 11 at a go, it's good, but it's not the best we could have come up with. There's a process to appointment, no doubt, but that can be done so well that you won't have to keep people waiting and then delay cases and then give people forever dates, to come back to the court and everything. So that's it. So, but basically, it's a good one. It's a step in the right direction. Then we know that now things will pick up faster than it used to be, and then we're better off for it. So that's basically what it is. So, but what's the second leg of your question?
No, I think before you even go on, let me also get Mr. Logan to also speak to some of these issues, and that has also been part of the advocacy that many legal analysts have been pushing for in Nigeria. So why do we have all cases, civil, criminal? Why do we all have them all ending up at the Supreme Court? So you both are, just a minute portion of lawyers who have cases due at the Supreme Court, not now, not next year, but 2-3 years' time as a result of the huge caseload over there at the Supreme Court. So what do you make of the suggestion that we should have, some form of, like a regional Supreme Court, and not all cases need to end up at the Supreme Court for the good of everyone?
If sincerely we need restructuring in Nigeria, and we agree with that, it can affect the sectors of our lives. But as we speak now, I think the central mentality is still holding us down. I said it, the Supreme Court became the highest court in Nigeria in 1963. How many years ago? So we should have been able to develop the system to the point where justice is brought closer to the citizens. And it's important. And that is why I pointed at the National Assembly. In a democratic setting, the National Assembly is the engine room, and you can consult these laws. So if that is what we want, we can achieve it. But as it is now, everybody must go to Abuja, and I don't know for whatever reasons. And there are several issues calling for attention within the judiciary, because when you also look at the burden on these justices, look at the last 6 months, for instance, these election tribunals and appeals and up to Supreme Court and all. In fact, if you know how many justices were moved away from their regular functions, right, just because of election matters, it also affected that. So if we are looking at effectiveness above efficiency, and you won't even want to combine the two, we should be looking at regional issues. I left the Nigerian Law School in 1989. It was just one law school in Nigeria, Victoria Island, Morocco Sandfield Law School. Right, yes. Now we have more than one law school in Nigeria. So can we also, in fact, when you look at our security architecture, we have the Nigerian Defense Academy, so can we decentralize? But I think some people are afraid about having true federalism in this country. And if sincerely managed, it will escalate and, activate a very impressive development in the country. We cannot be sharing the details. You know how much it costs you as a lawyer to say you have a matter in, if your client is not solid, you may have to travel by night bus and things like that, so you know how much a ticket. And sometimes all you just go there to do is just to get a date.
And there are people who even abandon their matters. They may have valid cases, but they abandon.
There was a time we had a matter, I was in the registry there, and they were telling me that they were attending to a matter of 2007 or so. And our matter arrived in 2014. But by the grace of God, God gave us speed, and we are through with that matter, and we succeeded in it. So these are issues. Nigeria should not be afraid to restructure. It's a very effective thing. What are we talking about? The resources are there. So the resourceful engagement of your resources, and the center will be the beneficiary. So you contribute to the center so that, and we can have the ease of doing business. We can fast track the processes of transactions and things like that. Because like my colleague brilliantly mentioned, justice delayed is justice denied. Sometimes by the time that justice finally comes, the subject matter is weary. So these are issues we should look at. Those who are our leaders should not be afraid to restructure this country in the realm of the resources we have, in the realms of justice dispensation, in any realm. And it should even activate diligence. If, for instance, states know that they have to go and generate their revenues and resources and there's no federal allocation, then if you are going into that office as a governor, you must be ready to work. So these are issues. But where are we today? So at least this is a step in the right direction. And we also need the contributions of the stakeholders. When you talk about the National Judicial Council, you have the Chief Justice as the chairman, then you have chief judges of state. You even have some who are not lawyers, but people who have been proven to have integrity. So you have NBA represented there. So all of them can come together and make recommendations. The NJC is answerable to the executive and prescribe. And again, National Assembly, why can't Nigeria be restructured? Is it because also you must go to the National Assembly? Then go back to the state and develop the governance structures there. So those are my submissions.
There's an angle of culpability of lawyers too. And one of the things that burdens the Supreme Court is, which the Supreme Court somehow has been able to manage, is all kinds of applications, frivolous applications, getting all the way. One of the, if you look at the criteria with which you become a senior advocate, you must have certain Supreme Court cases as part of what you have to bring to the table. Now, so criminal and also civil matters. So because of that, you find that people push matters that have no bearings, that have no reason to be at the apex court, just to have, that some form of representation.
Because that's part of the requirements.
So, and somehow, I think lately, the Supreme Court has been able to, figure that out. And you find that even some applications and cases that were brought by lawyers, you saw them imposing certain fines in millions, not even on the client, but on the lawyer, that for you to bring this kind of thing, this is not supposed to be here and you should be knowledgeable enough. So that's one of the things that in the recent years have burdened the Supreme Court. I'm not going to lie, it's something he can testify to, but that's part of, the culpability on the part of lawyers. Right. Because you want to get yourself there, you just carry anything there. And it's not supposed to be.
And again, speaking of the NBA, when an announcement was made, call for applications to the Apex Court, it seemed to also be a fine moment for the NBA to, perhaps, recommend, persons or even, or lawyers, eminent lawyers of good standing to also, who have been eyeing that opportunity to vie for the position, but we didn't see that happening yet.
No, I was following my law school platform, and they raised this issue of MBA recommending, and the persons put forward by the MBA they didn't make the list. Now, the recommendations come from different quarters, and if you look at this list, there was an initial list of 22. Where you have, then you have the priority candidates, and then you have the reserve. Now, so that is always the pattern. They can't take everybody. And like Mr. Logo rightly pointed out, constitutionally speaking, there's a number that is supposed to be there. We will not say because we want to accommodate everybody that we will now go outside the Constitution. The judiciary is supposed to interpret and protect the law. Now, so the judiciary shouldn't be seen violating the law. So whilst all the interests will be catered to, at the same time, things must be done decently and in order and according to the law. That's why you find that what is required has been met, and then, well, it may look unfortunate for those who didn't get there, but that's the way it is. It's the law, and the law is the law. You can't do anything against the law.
And are you disappointed? Because there was we even saw of lawyers and judges saying, do we want lawyers to just skip the process and come and join us on the bench?
It's not a tough case for me. The National Judicial Council has been given that responsibility constitutionally, and there's an interview committee that we interview candidates and make recommendations to the council that will be forwarded to the president and eventually to the Senate. And I just want to speak on this issue of lawyers bringing frivolous cases. I think the Supreme Court has started in the right direction. Let me commend Justice Kanyip of the National Industrial Court. This is a very brilliant justice who will tell you point blank that you cannot come into my court and waste my time. Absolutely. That I'm not here just to listen to you, but to conclude cases. That go to the library, go and study. And that's why we call it the bench. The bar cannot be taking the bench round the circle. So if the bench insists that follow and that's why I was so interested in the sensationalism of the election tribunals. You know what to do it. Help the bench. The bar should help the bench. But if we begin to introduce consequences, then you know that if you are going there, you are not going there to waste the time of the court. There had been matters that were kept in court for 12 years, 14 years, 15 years, 16 years, just by all these sharp practices. So the bench also should be awake to her responsibility of streamlining the procedures of justice to actually deliver justice timelessly.
Right, and two quick things now, or two quick submissions from you both before we sign out of this interview, and that is the development in Osun State. The NJC had their regular meeting. A judge in Osun State has been recommended for dismissal for issuing a controversial garnish order, and also crucial is the interference, so to speak, of the governor calling or recommending the removal of the CJ. But we've seen the NJC asserting itself, so to speak, saying you don't have the powers, you're way out of line, both the governor and the House.
Every time we come here, we've not hidden the fact, the judiciary has been in the eye of the storm. And they say this, remove this, do this, do that. And we always emphasize and state clearly that the judiciary has its own internal cleansing process, which most times people don't know or people don't appreciate. And a lot of times people just come here and cast aspersions on the judiciary, particularly, like the electoral matters that just went by. It's a contest between two persons. Once you get justice, the other person will start saying the judiciary is this, the judiciary is that. The moment that person gets a better one at the next level, then the judiciary is good. Now, but on what happened at Osun State, it just shows you how the judiciary works. When I saw the governor come up with his own antics trying to remove the CJ, it was just laughable, because we know that at the end of the day, the body responsible for this thing, and they've acted right and done it well. And you saw also the judge that was removed, and how he was recommended for retirement. It's as simple as that. The judiciary is the best thing that has happened to this country, and it is still the last hope, the hope of the common man.
Common man. Your final submissions quickly.
We have the institutions in Nigeria. Let's allow them to work. You see, if there are constitutional provisions, let it run, and let's all be subject to the rule of law and not to sentiments and sensationalism. And when we all come together, we can develop the system we have to help our nation develop, when all stakeholders rise up to their responsibilities. So we look forward to having the full complement in the Supreme Court of Nigeria, and proactively, sustainably so that you look at not allowing the gaps to repeat themselves. So, and on that note, we want to wish Nigeria the best going forward, and wish the judiciary more strength
All right.
to deliver justice.
And sadly, you know, a member of the reserve list, Joseph,
yes.
Justice of the Court of Appeal, Joseph Ike, died at the age of 65.
We express our
A
condolence.
really sad one, and we pray for the repose of his soul. Gentlemen, Boswoshu Fowora and Jide Ologun, we thank you very much for your time with us on
Always a
TVC
pleasure.
Breakfast.
Thank you. God bless Nigeria.
Amen.